You have a 2-year green card and the expiration date is coming up. Hi, I'm Ellen Sullivan from Cambridge Immigration Law, and today I'm going to tell you what you need to do to renew that card. There are 2 ways to renew your green card. The first way is the rule, which is you file your green card with your spouse. That's called a joint petition. The exception to that rule is that you file your petition as a waiver, or meaning special permission to not file with your spouse. You can get a waiver of the joint petition for 4 reasons. The first reason is death of the U.S. citizen spouse, divorce from the U.S. citizen spouse, abuse by the spouse during the marriage, or a catch-all extreme hardship reason. Now let's talk about the timing of your renewal application. For the joint petition, you have to file the application in the 90 days prior to the expiration date on your card. That means you can't file it too early, and you really don't want to file it late because it causes problems to you. If you are filing your green card renewal based on one of the exceptions, death, divorce, abuse, or hardship, you can file anytime. You can file early and you can file late as long as you can prove a reason for filing late. Whichever route you're choosing, a joint petition or a waiver, you need to remember that this step is super important and super critical for your ability to stay living in the United States. The government is looking for reasons to say that you and your spouse engaged in fraud and this is a fake marriage. So you have to submit a lot of evidence to challenge that assumption by the government. You submit letters from friends and family, photos of your vacation, bills that you pay together, a mortgage, a lease, all types of documentation. Generally, for my cases, I submit 200 to 300 pages of documentation. The renewal application that you submit must be well documented and well prepared. Here at Cambridge Immigration Law, we generally submit our renewal applications with 200 to 300 pages of supporting documents. Those documents are going to go to proving that your relationship with your spouse was a real marriage. The government thinks that you faked it, that you're lying, that you paid your spouse to get a green card. So you need to submit all these papers to show the government that it was a real marriage. The documents that you'll submit might be letters of support from friends and family, vacation photos, Christmas cards, birth certificates from your children, leases, mortgages, auto insurance, anything that shows that you and your spouse lived together and really were in a marriage. Now, if you're filing on another basis, a waiver, death, divorce, abuse, or hardship, you need to also submit information to go to that special reason for you not to file a joint petition. If you're filing your case based on a divorce waiver, it's important to remember that the government must have a final order of divorce to approve your case. But for me, as your attorney, that doesn't mean I can't file your case based on divorce before your divorce is final. And we do that a lot. Clients come in, I learn that the couple is separated and they want to get divorced, but they need to meet the expiration deadline for the renewal application. So what we do is we get your divorce started and we submit whatever we have to show that the divorce is pending. Once we have the full and final divorce, you'll add that to your filing for the government to be able to approve your case. If you're filing your case based on an abuse waiver, there's special documents we need to submit to prove the abuse. Police records, medical records, court documents, other documents showing there was abuse. Now, you might not have those types of documents, and in those cases, we rely heavily on a statement from you that tells your story. It explains how you fell in love, why you fell in love, and then what happened. Here at Cambridge Immigration Law, we've worked with a lot of people in your situation, and we do know how to tell your story in a way that makes the government understand what happened. In all of our abuse cases, we connect our clients to doctors or therapists who can write a letter talking about what you experienced with your abusive spouse. This is a critical piece of information to help the government understand what happened. Here at Cambridge Immigration Law, I don't think we ever submit cases without a doctor or a therapist report. They're that important. They can be the tipping factor for the government approving or not approving your case. Now, other things we submit on abuse-based cases will also include police records, court records, medical records, and often letters of support from your friends and family who know what happened in the relationship. If you're filing based on abuse, there may be other documents that we'll want to submit. If you have police reports, medical records, court records, we'll submit those documents to show what happened in your relationship. Now, one thing I want to note here is that you may still be living with the person that abused you. You may not be divorced from the person that abused you, or you might be divorced. All of those situations are covered under the abuse-based waiver. The government here, as long as we can prove the abuse, the government wants to get you out of the abuse. And if you're still in the relationship, the government knows that winning your green card renewal will be a ticket to get out of this unhealthy situation. So now that we've talked a little bit about the types of cases that we'll file, a joint petition or a waiver petition, I'm going to tell you a little bit about the processing. You file your application. A few weeks later, the government will send you a receipt. It's a piece of paper that's really important. That paper states that your green card that may already be expired by the time you get the paper states that it extends your green card for 2 years. So when you need to travel outside the US, when you need to get a new job in the United States, you will use your expired or expiring green card with the receipt notice to prove your status. So when you get your receipt notice, it helps you prove your status for 2 years. And you're going to need that receipt notice for a long while because the government's taking about a year, if not more, to approve the renewal applications. Now, some folks will become eligible to file for citizenship before the renewal application is even approved. This is a great time to submit your citizenship because 1, you'll become a citizen, and 2, submitting the citizenship application will help prove your renewal application. Once you file your application and receive the receipt, your case is probably just going to be pending with the government until it's approved. In some cases, however, the government writes you a letter and asks for more evidence about a particular part of your case. The letter is called a request for evidence, and the government might ask for information about your marriage, the divorce, or abuse. You will respond to that letter with the information requested because if you don't, your case will be denied. So you will respond, and then ultimately, your case will be approved. You'll receive a paper approval notice, and then you'll receive your 10-year green card in the mail, proving your status as a lawful permanent resident for the next 10 years. The renewal of your 2-year marriage-based green card is an important and required step for you to remain living in the United States as a lawful permanent resident. It's complicated, and you do not want to mess it up. You want an experienced attorney on your side. Here at Cambridge Immigration Law, we're excited to help you. If you're ready to get started, please schedule an appointment using the website below. We can't wait to work with you.